Now, I know the Minister partly touched on this in her closing speech, but I thought we should just make it very clear. Does the bill give the government the power to stop people growing food in their backyard, their vegetable gardens?
No, people can grow food in their backyard.
Minister, do you just want to make that a little bit clearer, because you said no people can grow food in their backyard?
No to the proposition.
Yeah. So if we can just have you set it out a little bit clearer, please.
Again, people can grow food in their backyard, and as I said in my summing up, the government is very supportive of people growing their own fruit and vegetables.
Thank you. Mr. Quilty.
So just to finalise that point, do the powers in this bill give the government the power to go in to pull up a vegetable garden if it's infected or if there's a problem, or is that just not going to, doesn't apply to domestic houses at all? Land?
Minister?
So the amendments will help safeguard food security, food safety and access to export markets, for example by preventing contamination of food from pesticides. The amendments will not result in the destruction of crops, nor will they prevent people from growing their own food. Information circulating online misrepresents and misinterprets the amendments of what's before the House today. There is a fact sheet that Agriculture Victoria has put together because they were aware, and it says it in the fact sheet, they were aware of issues that have been raised in social media and have been very clear in dealing with 7 claims, and I'm happy to go through those claims with you, but can I also suggest that if people are particularly interested in this, that the document can be found on www.agriculture.vic.gov.au. It deals with the claims in relation to the state government passing a bill now, which means that you won't be allowed to grow your own food. They can forcibly come in and rip it all out, and I've just given the response to that with the last question that was raised. The second claim that is out online is that landholder consent will no longer be required for authorised officers to take samples, stock, animals or documents. The facts are that the landholder consent is not required to take samples, specimens or remove documents under the existing Act. This is unchanged by the agriculture legislation before us this afternoon. The third claim is that there will be an increased enforcement powers to search property and persons without a warrant. The facts are Clause 10 of the bill contains amendments to Section 54 of the Agricultural and Veterinary Chemicals Control of Use Act of 1992, which introduced new inspection and enforcement powers subject to constraints. These amendments address outdated requirements of existing powers available under the Act. Amendments in the bill will not allow searching of residents without a warrant. There are no powers to provide to search a person. The amendments include a requirement for the authorised officer to present identification and to take reasonable steps to notify the occupier before an inspection. The fourth claim is authorised officers will no longer be required to present identification under new Section 53 in brackets 4 of the Agricultural and Veterinary Chemicals Control of Use Act of 1992. The facts are there are only limited circumstances where an authorised officer would not need to present identification. For example, when an authorised officer needs to access paddocks or bushland in remote areas to assess compliance and the property owner is away or cannot be located. Secondly, an authorised officer will be required to leave a notice of entry if no persons are present. The notice must include the time and purpose of the entry, a description of all things done while at the place, in brackets, or in the vehicle or vessel or aircraft, the time of departure as well as the authorised officer's name and contact details. The proposed requirements to leave a notice without the occupier being present is consistent with other existing legislation administered by Agriculture Victoria, for example, Section 82(4)(c) of the Catchment and Land Protection Act of 1994. A rare circumstance when notification may not be provided by an authorised officer would be if there was a risk of evidence being destroyed. For example, if an authorised officer was in a paddock or bushland and collected a sample of a suspected illegal bait, notifying the occupier could allow them to remove and destroy the evidence before the authorised officer could get a sample analysed and returned with a search warrant. The new entry and inspection powers require the authorised officer to justify that their actions were reasonable and within the constraints of the powers. Standard operating procedures will be prepared for authorised officers on exercising their powers for entry. These will emphasise a conservative and cautious approach to ensure that any evidence gathered can be used in any enforcement action. This approach is consistent with other existing legislation such as the Environment Protection Act 2017. Section 53(3) maintains the existing requirement that, if requested to do so, an authorised officer must produce their identity card before or at any time when exercising power under this Act. The new Section 53(4) makes it clear that this doesn't apply if the request is unreasonable under the circumstances or the powers exercised by post or electronic communication. Circumstances that would be unreasonable would include situations where the production of their identity card would require the authorised officer to undertake excessive travel or where it would delay the collection of time-sensitive evidence. The fifth claim is there will be heavy penalties for obstructing entry to property under new sections of 54J and 54K of the Agricultural and Veterinary Chemicals Control of Use Act 1992. Facts. 54J relates to failure to comply with a requirement of an authorised officer. A person must not, without reasonable excuse, fail or refuse to comply with a requirement of an authorised officer under this Act. The new section includes protections to provide an exemption where there is a reasonable excuse to not comply. An example of this situation where an authorised officer requires a person to produce a document but they are unable to do so as they are stored within a safe that the person cannot access. 54K creates an offence of obstructing an authorised officer or a person assisting an authorised officer. A person commits the offence if they obstruct, threaten or intimidate an authorised officer who is performing a function or exercising a power, or a person who is assisting an authorised officer. Offences for the obstruction, threatening or intimidation of authorised officers are common to other Victorian legislation, for example, the Livestock Disease Control Act of 1994 and the Summary Offences Act of 1966. This offence is required to allow the authorised officers to conduct lawful investigations unhindered. The maximum penalty for this offence is 100 penalty units, which is appropriate to deter offending. There's another claim that says that fines will increase from $1,800 to $10,000 for providing false and misleading information under the new Section 54L of the Agricultural and Veterinary Chemicals Control of Use Act of 1992. The facts are that penalty units for the new Section 54L are consistent with existing offences. There is no increase. The existing Act includes offences under Section 59 for false or misleading statements that relate to chemical use. For example, advising a person to use an illegal chemical or stating that there are no spray drift sensitive crops next to the target area or applications under the Act for licences or permits. The intention of the new Section 54L is to dissuade a person from providing false or misleading information to authorised officers. This could include falsified records of chemical use or vexatious complaints against a neighbour. The amendment intends to allow authorised officers to allocate time more effectively, otherwise wasted on these vexatious complaints and issues. The bill does not include a separate amendment to Section 137A of the Livestock Disease Control Act of 1994, which increases the maximum penalty for making a false or misleading statement from a penalty of 10 penalty points of 1,817 to 60 penalty points, 10,904. This increase is proposed to deter behaviour that puts Victoria's livestock industry at significant risk. False and misleading statements relating to the Livestock Disease Control Act of 1994 have the potential to severely impact on the integrity of our traceability systems and consequently damage trade relationships. Examples of false and misleading statements include fraudulent use of vendor declarations, livestock identification tags, and other documentation relating to livestock traceability. The penalties described in legislation are maximum penalties. The actual penalties handed down are determined by the courts. The courts may impose penalties at the higher end of the scale for offending resulting in high levels of risk of harm or repeat offending. There's one further claim, and the reason that I'm doing this is because the amount of misinformation that has been online for such a long time, it meant that the Department of Agriculture Victoria did have to try and provide the real facts in this fact sheet. So I think it's important that I actually read it out so that people do understand the reality. So the final claim that I'll read out is this. The claim is that the government is putting in place laws which would allow them to charge Victorians the money it costs them to destroy their own food supply under Clause 20 of the bill, which amends Section 58 of the Agricultural and Veterinary Chemicals Control of Use Act of 1992. So the facts are that destruction orders are an existing provision. Destruction notices are an appropriate tool to manage high-risk incidents such as contaminated crops or unlawful use of chemicals. Destruction notices can only be issued when the sale or the use of a chemical product, fertiliser or stock food is prohibited, or the agricultural produce is or likely to be contaminated by chemicals such as pesticides. No changes are proposed to the existing limited circumstances when destruction notices can be issued. Amendments to Section 58 will broaden the scope of destruction notices issued under the Act to allow discretion for alternatives to destruction, such as recycling. The current Act limits the scope of a destruction notice and is not consistent with Victoria's policy for waste, reuse and recovery. The terminology, in quotes, or otherwise dealt with, end of quote, proposed in the amendments to Section 58 will provide a broad scope of options including reuse, recycling or treatment. For example, an authorised officer finds a person not trained and authorised to use an agricultural chemical product. The best outcome may be to issue a notice requiring them to return the agricultural chemical to the manufacturer for potential reuse rather than destroying the product. The Act currently allows for cost recovery from an owner who has been issued with a destruction order, in brackets, if they do not comply with that order. The amendment clarifies that cost recovery may be achieved via a court and is consistent with other existing acts, such as the Environment Protection Act of 2017. I hope that assists people who have been concerned about the various mixed messages and claims that have been circulating online for some period of time.
Mr Quilty.
Thank you, Minister, for that. Was very comprehensive. Does the bill prevent anyone from slaughtering their own animals or game animals for their own consumption?
Minister.
Thank you, Deputy President. The answer is no.
Mr Quilty.
Well, how about for slaughtering their own animals or game animals or feral animals for dog food for their own dogs?
Minister.
They would be able to do it.